Final case is Leavenworth County, 128-948, Whiskey Ridge LLC et al. Versus Leavenworth County Commission and Mike Steben. Who do we have here for the appellant?
Good afternoon, Your Honor. Steve Maurer and my partner Jamie Walker here on behalf of appellants Whiskey Ridge, Orson, Dan and Cindy Lynch, and also present in the courtroom are Mr. and Mrs. Lynch.
And for the appellee?
Good afternoon, Your Honor. Alex Gilmore for the Leavenworth County Board of County Commissioners.
Brady Sullivan on behalf of defendant and appellee Mike Steben.
And are you both going to be arguing?
Yes, Your Honor. We've worked out time limitations, but I'll take the first 10 minutes and Brady will take the remainder.
Okay. So we'll start with the appellant. And do you wish to reserve any time for rebuttal?
Yes, Your Honor. I have 23, please.
And that is granted.
Thank you.
Whenever you're ready.
May it please the court. My name is Steve Maurer, along with my partner, Ms. Jamie Walker. We represent appellants Whiskey Ridge, Orson, and Dan and Cindy Lynch. Mr. and Mrs. Lynch are also here in the courtroom. This matter arises out of my client's attempt to operate their business, a wedding and event center in Leavenworth County. I know the court's familiar with the facts, so I'm going to dispatch of a long discussion of the facts, and I'm going to get right to the issue that is the principal issue for this court's consideration. And I think it's probably unique in the court's experience because it's not often that this court might hear a case where it is absolutely undisputed the court below made an error. It is undeniable and agreed to by all parties that the court below, the district court, was wrong in its application of Kansas law. In this instance, the court.
You're talking about the standard of review.
Yes, Your Honor.
Following the federal.
Yes, Your Honor.
What remedy?
I'm sorry?
What is the remedy for that?
The remedy is, well, we believe the remedy is to consider the case improperly decided, and we should be remanded back to the district court, and we should be able to go forward to conduct our discovery, to establish our case, and have our opportunity to present our arguments to the court. Defendants will argue, well, yes, there's an error, but since your scope of review is de novo, you can go ahead and apply the Kansas statute correctly and still find in our favor.
Why is that not a proper remedy? That seems to me as an appellate judge, the most efficient thing to do. I mean, again, the standard of review is bad. I agree with that. And you're entitled to a much more favorable standard of review, but it is a de novo review on essentially undisputed facts. Why can't we just go ahead and do that? Or shouldn't we do that?
Well, you certainly can, Your Honor, but if you apply the proper Kansas standard of review, which is if the petition has any factual allegations which could state any claim under any theory, whether it's a theory that we articulated or not, then the case gets to go forward. And if you utilize that standard, then under the undisputed pleadings, then the case has to be remanded and we get to go forward. The only thing that the district court pointed to and relied upon in making its decision to dismiss our case was other extraneous evidence presented by the defendants in support of their motions to dismiss. And unlike what's required by Kansas procedure 6212D, when a motion to dismiss relies upon and attaches extraneous additional evidence beyond the petition, then the court is to treat it as one for summary judgment and give the plaintiff an opportunity to present its own material evidence. Unlike the argument you just heard, where there was a bench trial, discovery, and then summary judgment, my clients were deprived anything. They were not given an opportunity to conduct any discovery. They were not given the opportunity to ferret out and develop the facts behind all of the facts behind their claims. We were from the very beginning confronted with the county's and the defendant's self-serving documents, which were not even authenticated, and then said, well, see, based on our own documents, plaintiffs lose, grant us, dismiss their case. which the district court did. The district court did not give us discovery, did not give us the opportunity to rebut those documents, did not give us the ability to present, to develop, discover, and present our own evidence.
Question about the tortious interference.
Yes, sir.
claims. And I assume we're dealing with essentially the second amended petition here.
That is what the district court did, yes.
Well, and you're not claiming that was error, are you?
Yes, I would, Your Honor, in that the First Amendment petition undeniably cured any procedural issue, and we should have been able to go forward on the First Amendment petition. We should have never been required to file an incredibly detailed Second Amendment petition because our First Amendment petition in and of itself was more than adequate.
Well, the question I have goes to what the agreement was that was interfered with. And as I read the second amended petition, at least, the agreement is one essentially from David Van Paris as senior legal counsel, that if certain things happened, Whiskey Ridge would be granted a use permit without the sprinkler system or the fire retardant requirements. Is that correct?
In part, Your Honor, yes.
What's the other part?
The other part is, as we alleged, we specifically alleged that the county commissioners knew of and approved Mr. Van Paris's representation to my clients that if you go get this waiver from the state fire marshal, you will be granted the SUP so you don't have to put in the sprinkler system. My clients did not know about the state fire marshal and the ability to go get a variance. The county directed them to do that. The county directed them to go get an engineer to give you a full scope review of the fire safety of your building, and we will accept that along with the variance. That was a promise communicated by Mr. Van Paris as attorney for the district, but it was authorized and approved by the commissioners.
The evidence of that, I mean, or even the allegations. I mean, I'm not sure I saw the allegations that it was approved by the.
In paragraph of the second amended petition, I believe it was paragraphs 58 and 59, we alleged that it was a binding agreement and to be binding, according to the defendants, it has to have been approved and authorized by the commission. So I think a fair inference is that. And then I also believe on page 25, I think it's paragraph 185 and 186, we specifically allege that the commissioners knew of their contract that if we got the variance, we would be given the SUP. And so we did allege that it was approved and with knowledge and authorized by the commission. And that is in there. If the defendants want to argue that Mr. Van Paris stepped out and didn't have authority, I guess they can take that position, but then they walk right into a claim of fraud or false or negligent misrepresentation, because my clients certainly relied upon it and they certainly have damage and they have every reason to believe that they could rely upon that representation. And so there still would be a claim that could be brought based upon the facts as we've alleged in the petition.
Did Mr. Van Paris, as you understand his role, have the authority to bind the county?
Absolutely. An attorney absolutely has the ability to make representations and bind their client. That is a strong principle of Kansas law, every state law that I'm aware of. And so, yes, Mr. Van Paris would have the authority. And as we pled, he communicated that to our client with the knowledge and approval of the county commission. The defendants and the district court tried to recast our tortious interference claim to say that we had an agreement with Mr. Van Paris and the director of planning and zoning, Mr. John Jacobson. We never alleged that there was a personal agreement with Mr. Van Paris or Mr. Jacobson. We alleged it was an agreement with the county, communicated by them. And so that is absolutely the basis or one basis of our tortious interference. And what matters, Your Honor, about that is as we've pled, we got the variance. The state fire marshal gave it to us. And then in an incredibly unusual, atypical behavior, defendant Stephen called the state fire marshal and told the state fire marshal, hey, why did you do that? We've passed zoning and we want all businesses, all construction to comply with the new building code throughout Leavenworth County. And we know that that's not true. We know that Leavenworth County exempted 1/5 of the entire county from the new building code. It only applies to 8 of 10 townships. We also know, as we've alleged, that we're the only ones that have been required to put in a sprinkler system. Every new construction in the county, nobody's had to do it except us, as we've pled. And it was so bad by Mr. Stephen that, as we pled, when he was confronted about making the phone call, he lied about it. He denied it and said, I didn't make any phone call. It was only after he was pressed and pressed and pressed that he finally admitted that he had done it. Which begs the question, Your Honor, if the variance was no big deal, if the variance didn't matter, if the variance wasn't part of the agreement, why to go to all the trouble to have the state fire marshal rescind it? And why lie about it? Of course it was important. Of course it was what my clients were told and promised and agreed to. And by the conduct of Commissioner Stephen, he tortiously interfered with it, as we've alleged, outside the scope of his authority, outside there was a commission of any commission meeting. He did it to politically retaliate against my client, Mr. Dan Lynch, because Mr. Lynch refused to provide political or financial support to Commissioner Stephen. And because of that, he retaliated against my client. And we have pled those claims. The district court completely brushed aside and ignored our claims of misconduct, ignored all our evidence of, and our allegations, of disparate treatment towards Mr. Lynch and my clients. In fact, our Second Amendment petition lists off 5 different examples of things the county has done just to retaliate against Mr. Lynch. And the district court in passing says, well, now the plaintiff says there's a pattern, but the plaintiff should have recognized the pattern at the time of Whiskey Ridge. Nowhere in our petition did we plead that those things occurred before Whiskey Ridge. We've alleged that those are incidences of retaliation against Mr. Lynch. The district court just bent over backwards to find a way to dismiss our claim and deprive us of our day in court or any discovery or an opportunity to even challenge the evidence put forth by the defendants, which included an unauthenticated YouTube video and documents from non-parties which were not accompanied with an affidavit. They wouldn't even satisfy the requirements for summary judgment to be admitted evidence, let alone on a motion to dismiss. I see my time is up. I'll reserve the rest for rebuttal unless the court has any questions. Thank you.
Good afternoon, Your Honors. May it please the court. My name is Alex Gilmore, and I represent the Leavenworth County Board of County Commissioners. The district court properly dismissed this case on 2 independent bases. We heard a lot of discussion today on whether or not plaintiff's second amended petition failed to state a claim. A plaintiff's position is obvious that they plead enough under Kansas notice pleading statutes. What we haven't heard today is any discussion on whether or not the district court properly found that it lacks subject matter jurisdiction. I would like to focus the court's attention this afternoon on that prerequisite. Kansas district courts have limited jurisdiction over the administrative decisions of quasi-judicial boards, including a board of county commissioners, zoning and planning decisions. That is statutory-based jurisdiction. There's 2 relevant statutes that I'd point the court to in this appeal. It's KSA 12-760, which deals with planning and zoning decisions by the Board of County Commissioners. That statute mandates that any aggrieved person who wishes to contest a final decision by a Board of County Commissioners has 30 days to file an appeal.
But as I read the second amended complaint, and it's this isn't contesting the zoning decision. It's seeking monetary damages for torts and constitutional wrong. Why does the exhaustion doctrine even apply here?
Yeah, that's a good point, Your Honor. And I think
They make good points every now and then.
and here's the answer. Kansas courts have consistently held that you can't collaterally attack decisions by a Board of County Commissioners on an independent cause of action claim, right? That's exactly what the plaintiffs are doing in this case.
It's not. They're not asking to have it set aside and they don't need a sprinkler system anymore. I mean, they're living with the zoning decision. They're seeking money damages for things that occurred along the way.
They are contesting the actions taken by the board and the Board of Building Code Appeals throughout the special use permit process, including alleging a takings claim that SUP 1 was taken without just compensation, that there was a substantive due process violation committed by the board because they deprived a property right from the plaintiffs as a result of these board decisions as it relates to their special use permit. So it is a collateral attack. They're sidestepping the jurisdictional appeal issue and they're doing it quite cleverly, but there's case law in Kansas that says you can't do that. We've
Required to exhaust as to their constitutional claims.
Yes, Smith, State XRL, Smith v. Miller, that's a tax valuation appeal. In that case, plaintiff didn't file an appeal through the process established by the challenging the tax valuations. Instead, he filed a petition later on, including claiming that the issues were unconstitutional. So that case is directly on point as it relates to an independent cause of action.
Kansas case.
Yeah, State XRL, Smith v. Miller, 1986, Kansas Supreme Court.
Well, I mean, with the constitutional claims, we would look at federal law and exhaustion. Isn't federal law fairly clear that you do not have to exhaust state administrative remedies to bring a 1983 action?
I think it depends on the claim, and I can't give you a clear answer on what the federal courts say. I can tell you that when Kansas courts are dealing with zoning challenges, which is what the defendants contend is occurring here, including independent causes of action, is that you do have to exhaust those administrative remedies first. And if you want to collaterally attack, like bring a constitutional claim, for instance, you would do that at the district court.
They aren't collaterally attacking it. They're asking for money damages. They aren't asking that the zoning be changed.
They're challenging the board's decisions affecting their special use permit, Your Honor. And by doing that, they're just alleging a different cause of action. They're not saying reverse or otherwise set aside the planning, the board's decisions with respect to planning and zoning, but they're saying that those decisions violated their constitutional rights. That's a collateral attack of the board's decision.
For which they're seeking money damage.
Correct.
Right.
But they still have to exhaust their administrative remedies first. If they had done so, then we wouldn't be here talking today about money damages and constitutional and tortious interference claims. If they would have appealed those underlying decisions, then the remedy was for the district court to send it back to the board for reconsideration. We wouldn't be here talking about whether or not a constitutional violation was adequately pled, because they would have exhausted their administrative remedies and had a remedy for the complaints that they now seek for you to reverse. Any more questions? Okay. I think that the record is clear based on the allegations of the second amended petition. I'm not asking the court to review the extraneous materials because the well-pleaded facts established that they didn't exhaust their administrative remedies. Regardless, I think this is a subject matter jurisdiction case. Kansas case law is clear that this court can consider extraneous materials when deciding whether or not the district court had subject matter jurisdiction. There's no requirement that we convert this into a motion for summary judgment, consider contrary evidence that the materials are, they're governmental materials, not subject to dispute. The plaintiffs have never genuinely disputed the authenticity. They're just saying, well, you didn't put an affidavit together, so therefore the district court improperly considered these. So I think that the case law is clear that the district court had the right to consider these on a subject matter jurisdiction dispute. And I think what's important to underscore to the court is that it's not a merit-based argument. It's the documents simply pinpoint the structure of events, the sequence of events that occurred as to why we ended up here, and not the sequence that I think that the case law and the statutes require, is that on 3 separate occasions, the plaintiffs had an opportunity to appeal decisions that they didn't like. They chose not to do that and continued to trud along. The Board of Building Code Appeals denied their request for a variance. Pursuant to county regulations, they had a right to appeal that decision under KSA 19-223. They didn't do that. Instead, they proceeded to submit a request for a special use permit without a fire suppression system. That was denied. Again, they had a right to appeal that decision. Instead, they went ahead and installed a fire suppression system and applied again for a new special use permit. The board ultimately granted them a special use permit after they installed their fire suppression system, and they put that as a condition to approval of their special use permit. Again, they had a right to challenge that and they never did so. Instead, they waited a year, filed this claim. And I think we've cited ample case law in our brief and in Defendant Stevens' brief as to why that's not presented under Kansas precedent. I'll reserve the remainder of time for Mr. Sullivan. Thank you.
Your honors, may it please the court, Braden Sullivan on behalf of appellee Mike Steben. I'd like to try to quickly cover 4 topics. Why the failure to exhaust applies to the tort claims too, why the tort claims fail independently, separate and apart from that analysis, why the failure to use the correct standard of review constitutes harmless error, and why it was not error for the lower court to consider materials outside the pleadings. As my co-counsel explained, the appellants had at least 3 opportunities to appeal the county's decisions and failed each time to do so within the time frame required by KSA 12-760. They now attempt to repackage these complaints as tort claims in an effort to circumvent the requirement to exhaust those administrative remedies within that time frame. However, we have ample case law cited in our briefs showing that that is not allowed under Kansas law. KSA 12-760 applies to any person aggrieved by the decision of a city or county. And this whole case, no matter how it is packaged, clearly boils down to the fact that the appellants are aggrieved by the county's decision to require compliance with the 2006 International Building Code.
Isn't what they're pleading, they're aggrieved by what your client did going to the fire marshal.
That is the underlying conduct, but our position is that is a part of the decision-making process as in relation to this SUP and these variances, all a part of, well within the purview of the county, whether through the Board of County Commissioners or the Board of Building Code Appeals. Our briefing outlines that this is well within Stevens' authority to do that as a valid ex parte communication. There's a case to that point, McPherson, in the briefing that I would refer you to for that point.
Well, that's the argument that it's not wrongful. I mean, that doesn't have anything to do with a collateral attack on the zoning variance or the use permit.
No, I think you're right, Your Honor, but there's 3 cases we cite to in our briefing to the effect or stating the legal point that you cannot circumvent the requirement to exhaust administrative remedies by bringing other claims outside of the that context. Those cases would be Johnson County Memorial Gardens v. City of Overland Park, State X. Rel. Smith v. Miller, and Sandlin v. Roach Labs. Each of those cases, there was a city or county decision with a clearly outlined administrative appeal process that was skirted around by bringing other claims.
They have brought a declaratory judgment action now saying that the variance was improperly granted and they were improperly required to install a sprinkler system. But that's not the claim they're making.
The underlying conduct and the underlying damages all arise from the same decision made by the county. And again, Stevens' conduct, the phone call that they complained of, is a part of that decision. In fact, the decision was made to require compliance with the 2006 International Building Code. And this phone call was an continuation of that decision to make sure that the fire marshal was made aware of the county's adoption of the more stringent code, which he himself then realized he didn't have authority to grant a variance to because of the county's more stringent code. Did I answer your question, Your Honor?
Well, you've given me an answer. I'm not sure I'm persuaded, but go on.
Again, there's language in each of those 3 cases I cited to stating that you're not free to pick and choose your avenue for the same underlying conduct or decision of the county. You must follow the appeal process outlined in KSA 12-760, and no matter which way you slice it, they are a party aggrieved by the county's decision, and that triggers their requirement to exhaust their administrative remedies, which they failed to do. I'll quickly also explain that Independent from that, their claims for tortious interference fail for various reasons. Under the latest theory pled in their second amended petition, which references the contractual agreement between Whiskey Ridge and the individual county staff members. The individual county staff members do not have the authority to bind the county as a whole. I acknowledge their position that the county adopted this position, but their pleadings make clear that this was communicated directly from the county counselor himself and was not from the board as a whole. And individual county staff members do not have the authority to bind the county as a whole. Only the Board of County Commissioners can grant an SUP, and only the Board of Building and Code Appeals can grant a variance. And any contract entered into by individual county staff members is unenforceable as ultra-virus under the ultra-virus doctrine and cannot form a basis for a tortious interference claim. And quickly, I'll just conclude by reiterating that the court's failure to use the correct standard of review constitute harmless error. One, even on the face of the pleadings, accepting all of their allegations as true, it's still clear that this arises out of their disdain with the courts or with the county's decision on the to require compliance, and thus they needed to exhaust their administrative remedies and they failed to do so. And also it's clear from the face of the pleadings, there was no valid contract or reasonable business expectancy that could form the basis of a tortious interference claim. Thank you, Your Honors.
Thank you.
May it please the court. I'd like to address your issue of what is our claim. Our claim is for money. We are not suing so that we don't have to install the sprinkler system as we've pled. We already did it. It's in. The problem for the defendants is that after they did it to us, we found out, oh, wait a minute, that's not really the standard. They haven't made anybody put in a sprinkler system. And there was more conduct by them where they are retaliating against Mr. Lynch and his businesses for political reasons. All of those things form our claims for tortious interference. They form our claims against the three commissioners, Katz, Culberson, and Steben. We've alleged they got together. They conspired to retaliate against Mr. Lynch for political reasons. Those form a claim that we're entitled to go forward and present and gather evidence and present. What has happened in this case, all you heard about was the exhaustion of remedies. You asked me in the beginning about my first amended petition. Your Honor, the whole exhaustion of remedies only arises from their motion to dismiss and all of the extraneous documents. The exhaustion of remedies begins with their claim that we should have appealed the decision of the BOBCA, Board of Building and Codes Appeals. There was nothing in my petition or First Amendment petition that even mentions the BOBCA. What has happened is they've recharacterized our claim as one for zoning and then introduced the BOBCA supposed decision and then said, aha, you didn't appeal that, so you're out. Even though—
Before your time is up, let me ask a couple of questions. Quickly give me 2 sentences of what your substantive due process claim is, apart from the equal protection claim. What's the substantive due process violation?
Substantive due process is that we were required to comply with a statute that no one else has been required to comply with, and we were not given proper notice as the county is attempted to dodge because we've pled, we did not get notice of the withdrawal of the SUP. We did not get notice of the decision that we have to appeal the BOBCA. In fact, the evidence that we've pled.
So it has to do with notice about the decision making.
Notice about the ramifications of the decision making. Yes, Your Honor.
Yeah. The other question I had from looking at the briefing, I didn't see a separate argument about the Kansas takings claim. Have you essentially dropped that?
No, Your Honor. We did include it in our briefing, I believe. The taking is that we had an SUP that was voted on and approved by everyone. COVID put it in hiatus. The county.
No, I mean, I understand that argument. I just didn't see anything in your appellate brief addressing that.
I'll have to look, Your Honor. I don't recall it off the top of my head, but no, we have not intentionally abandoned the takings claim.
All right.
I see my time is up. May I have one moment to conclude?
Yes.
Thank you. Your honors, for all the reasons stated and for all the reasons set forth in our briefs, we respectfully request that this court reverse the district court, remand with directions to go forward to allow my clients to develop their case and ferret out all of their causes of action. Thank you.
All right, counsel, thank you all very much for your briefs and your arguments. We will take the case under advisement